Welcome to the Freedom Unchained channel. I was going through some Christian Walters. Not sure if you've heard of him, but he, I guess, went from doing like creditor, debtor, secured secured party stuff into exclusive equity or exclusive trust, pretty much, more focused on trust. So he has a system he refers to as new trust technology. And I got a document that I want to go through, understand it before I actually implement the first step, which is correcting the IRS master file. Because my understanding is the IRS master file is reflected by all other agencies. So once you correct that, all other agencies have to account and adjust to that. So that's what we're going to do today. We're going to go paragraph by paragraph, get an understanding, pull out everything we need to know about how to correct the IRS master file. I believe it's done with an affidavit, where you could use a 1040X, but I probably don't recommend that. I'm not a fill out form kind of person at this point. I might get to that point once I start developing trusts and then allowing my sub-trusts to interact with the public in commerce. And then I might want to fill out some kind of form, make sure it's clear how I'm acting, but let's just get into it. I uploaded the Christian Walters Explains New Trust Technology, Moving Banking, Money Banking, and Trust to Move Titles and Commerce with Christian Walters. It's a document, and I want to go through it paragraph by paragraph to get some understanding, and then we can implement the first step once we do that. Keep everything short and make sure you're pulling exactly the words from the document. I guess I wasn't specific enough to pull the document out of my project, so we'll just upload it really quick and say, start with, it's all about trust. That paragraph.
Quote, open quote, it's all about trusts. A gentleman asked a question earlier, and I would like to explain. Everything I've been doing in the past, I've realized it was debtor-creditor, and I realized that we were doing everything all wrong and backwards. I really changed my whole focus. Everything is completely different now. I'm gearing everything towards trusts. It really makes more sense. Once you get into trusts and study trusts, you find out a lot of what didn't jive under debtor-creditor all of a sudden makes sense under trusts. I'm switching everything into the trust mode. Instead of doing debtor-creditor, I am going to stick with trusts. I'm going to live, eat, and sleep trusts. For those of you who haven't been in it since we started switching over back in November of last year, November, December, and January, I would suggest that you go back and check out my website, which is movingtitles.com. Keep an update on that site as I'm putting different information on there and gearing that site solely towards trusts. I'm leaving the debtor-creditor behind. Not that I might never use it as a hybrid, but you really can't get a remedy as secured party creditor. Your remedy is in trusts, and it's commerce through trusts and equity. In a trust, you are the lender of an asset held in special deposit. And if you don't express the trust, you are the debtor under the UCC debtor-creditor relationship. You would have to bond the case, and the bond is really with the trust. A bond is a trust in a trust relationship. Here we have been talking about trusts all along, but we've been construing it along with everybody else because we never expressed it as a trust. So they are construing it and getting us to function under debtor creditor, under UCC, except for value return for value and everything like that. After this one, the part beginning, we have things in trust that are similar to those in the same full paragraph style, close quote.
Yes, I think that one's simple, clear, and to the point. Let's move on to the next paragraph. Give me the full paragraph, please.
Quote, open quote. We have things in trust that are similar to those, although I wouldn't call them except for value. It's all really explained in Gilbert law summaries. Trusts as a basic primer for statutory trusts, which is really the black. The trust that we really are talking about is the white trust, which is opposite the black. But if I teach what the black is, you'll know the white by sight. To give an example, the AFV RFV under debtor creditor, which in my opinion and the evidence I've discovered, which is not exactly strictly opinion, but based on the evidence I've discovered, what we were doing by AFV RFV was creating a lien, which was under UCC, which was a negotiable instrument. And anything under negotiable instrument law is debtor creditor, and you are creating a debt. A debt is what we are using as money in the system today, and it is functioning as credit. Credit is what we use as money. These liens that we are creating, that we were putting our unqualified signature to, which is the rule of the signature that I go by in expressing the trust. But since we are not expressing it as a trust, we are creating a lien. So what we're doing is just making a bigger debt to pay another debt. We got double debt upon debt. They love us for that because we are creating more money for them to utilize. Here all along, we thought we were getting some kind of set-off, and we weren't even touching the set-off on the private side. We weren't doing a discharge on the public side. We were just adding to the debt, the public debt. It is my conclusion that we no longer any AFV RFV because there is a better route, and that route is 180 degrees the other direction. I think that is what they were using to lead us down the path by giving us a few bones here and there of successes, because I don't know anyone at all who can claim a 100% success rate on any methodology that they use out there. No matter from AZ, whether it was litigation, redemption, OID methodology, everybody has a success rate of about the same. That made me wonder why. Why is it that it looks like you could throw a garbage can lid in there and get a remedy to some degree, when somebody could take somebody's success and duplicate it exactly the same way, and they don't get a success? That made me wonder why.
All right, so if you don't know what AFV or RFV is, it was up in the first paragraph. Accept for value, return for value, the UCC thing people try to utilize. Another thing that he brought up in this section is the unqualified signature that they use. When you just sign anything, they can kind of use that to create debts in your name. So I think what we're going to be learning is to how to qualify our signatures, use the proper titles, kind of the all rights reserved, and all that kind of stuff. So they can't use our signature for creating bonds or debts or whatever they do, and that will give us more authority to get them to act properly. My understanding on that. Yes, that was pretty clear. Let's go on to the next paragraph.
Then with this trust stuff, I was studying all along. The more I studied trust, my eyes got opened up to the fact that, hey, it's been trusts all along. All of us has been talking about trusts, but we have been talking about trusts only in a protection method for protecting assets. That was just a device for protecting assets of the debtor from the creditor attacking him. We want to put it into trusts, treating trusts not as a defense move, but solely as an offensive move. I've been finding out that's what they have been coming at us with all along. It just looked like debtor creditor, because debtor creditor and trust relationships are so closely related, they look similar on the surface. When you dig down in there, you will find out they are a little bit different. When you find out trusts are operating in a totally different world, in equity, and here we thought it was admiralty all along, which is nothing more than debtor creditor. They were taking you into admiralty to force you into breach of contract. But really, there can't be any contract because there is no money. You can't give a value for consideration. Under trusts, you don't have to give a value of anything. It's a thing. Whatever the thing is, the res, that is what is put into the trust. That's the principal. That is the property. That alone should tell us something. The fact that most of us were getting the debtor-creditor relationship is so closely related to the trust that you have to dig down into a little bit. Plus, it operates solely in equity, And that is where the trust power is. That was like the admiralty coming at you under debtor creditor, which was operating and taking you into equity. And then for the enforcement, then you got the breach of the duty under equity, because equity is not compelling you to do the duty. When you didn't do the duty, you wound up in jail or you owed a debt and they foreclosed. Really, it is the same as the trust. What we thought was admiralty or debtor creditor was really trust. If it walks like a duck and talks like a duck, it's a duck. We are talking about the actions of a trust. If it walks like a trust, talks like a trust, then it is a trust. That's the whole secret. No parties in the trust need to know they are forming a trust, including the grantor, the trustee, and the beneficiary. That does not negate the fact that a trust was formed. If the law recognizes a trust, then there is a trust.
All right. So I forgot I have this beautiful microphone. So hopefully that'll have the audio a little clearer. So let's move on. Or actually, let's pull out the important part. I think the most important part was if it talks like a duck, or excuse me, the sentence where he says, if it walks like a trust, talks like a trust, then it's a trust. If it walks like a duck, if it talks like a duck, it's a duck. So what these courts are creating are trusts. Everything in our life, we go and create multiple trusts every single day, even if we haven't expressed it properly on paper, because all the aspects of a trust are there, then there is a trust and there are beneficiaries, grantors, trustees, there's obligations, and there's rights as well. Okay, so I think that's pretty straightforward. Let's get to the next paragraph, please.
Here's the next full paragraph after the one we just did. Quote, open quote. As long as I have the elements, intent, purpose, parties, and specific res, and one of the methods of formation, then I have a trust. As long as I can prove that after I've made a claim it's a trust, then I have standing to come in and make a claim as, say, the beneficiary, and say that the trustee didn't make a payment or disbursement. Then the burden of proof after I get a prima facie case against the trustee, a court of equity assumes that the trustee is guilty.
All right, so this is an important paragraph. As long as all the elements, intent, purpose, party, and specific res, and one of the methods of formation, then you have a trust. Then when you go in and make the claim that it's a trust, and then you have proof of prima facie case against the trustee, because what you're doing is saying that you're the beneficiary, and then the state or the public officials go from the beneficiary to the trustee, then you have a prima facie case against the trustee. The court of equity assumes that the trustee is guilty. All right, let's move to the next paragraph.
That is exactly what they were doing when they took you from admiralty into equity. The same thing happened there. The strength comes in equity, where the court is going to assume the trustee is guilty, didn't make a payment, and the only way that the trustee can prove that he is innocent is that if he has a record that he made a payment. The only thing a court wants to know at that point, when are you going to make a payment? If you are not going to make a payment, then you are in contempt. There is where the power of the trust comes in. It's in equity. Here, all along, we were talking about a trust operating in equity with a different face, thinking it was debtor-creditor or admiralty, and it was not. They are tricking us to come under debtor-creditor, under UCC, creating these negotiable instruments, thinking we are going to do a set-off or discharge, and there is no way possible. How does one get a remedy then?
All right, so I think that paragraph is simple, direct to the point. If you don't get it, then you probably need to go learn some fundamentals, and then come back to this. All right, can you give me the next paragraph?
Even though the remedy is not in the creditor-debtor relationship, the secured party creditor, the remedy is in trust, commerce through trust. It's not knowing who you are as a secured party creditor. It has nothing to do with that. That is going in the opposite direction. Knowing who you are as grantor is the important part. If you are the grantor of the trust, and say the beneficiary in one case, or maybe the grantor and the trustee, then you've got different powers through the parties, whichever way you want to play it. The key is whoever is the signer on the instrument. That was the grantor of the whole thing to begin with. That is where it all began. If you didn't express it to be a trust from the beginning, here it was a trust because there is no money and everything has to be a trust. When you go to the grocery store to buy groceries, you think you are paying for something with Federal Reserve notes, and that is just your purchase. You aren't purchasing anything. You are forming a trust. The same way at the gas station when you buy gasoline for your car. You aren't buying gas. You are forming a trust. Everything today has to be a trust. We are forming hundreds of trusts a day, probably in some cases. Are we treating them as trusts? Did we realize they were trusts? I don't think so. Now, if they give me an offer that comes in the mail in an electric bill, I'm going to treat it as a trust. It's an offer for a debtor-creditor relationship only if you don't know that it is a trust. I'm going to express it as being a trust by forming the four elements necessary. I am going to have intent, purpose, parties, and specific res. I'm going to turn that offer into the specific res. I'm going to return it to them as the special deposit under trusts.
All right, so once again, that's not too complicated. Idea, everything's a trust. You treat everything like a trust. A lot of this debt court stuff is going to become a lot more simple. So that's what this is all about. I don't think we need to pull anything else out of that. So let's just keep on moving. All right, let's do the next paragraph.
If you look under Black's 4th edition revised, it says under the definition of trust deposit. Trust deposit. A trust deposit is for the purpose of the depositor to make a payment for an obligation or a debt or some other purpose. Whatever the grantor wants to do, he really can do, as long as it's for a lawful means. I could use that deposit to pay a debt or an obligation. I could give the specific order to do conversion and convert the assets to say money, whatever their money is, and take care of the debt. The remedy is really not in debtor-creditor, it is under trusts. We are really moving titles in trusts, functioning as commerce. My bond is my word, and my word is really my bond. And really, we are talking about a trust, a pledge, a duty, an obligation for a party called the trustee to do whatever the will or the purpose of the grantor for the benefit of another party. The third party could be another party, or it could even be the beneficiary or the grantor himself. So what I liken to debtor-creditor under AFV-RFV is really in Gilbert Law summaries. Trust on page 127 under A there. And PACTA 441, it's talking about the alienability of beneficiary's interest. We also want to see Turek 98 on page 27 for a tie-in.
All right, this paragraph is pretty much expressing that once we understand it's a trust, we identify our proper position, then we can go ahead, put a trust deposit, and then offset the debt, convert things, and make performance under certain duties and obligations of the party called the trustee. Yeah, so let's move on to the next paragraph.
1. Right to transfer. In general, 441. Beneficial interests in a trust are freely alienable, that is, a lien by the beneficiaries, unless there is a valid provision to the contrary in the trust instrument. Thus, a beneficiary can assign, pledge, or encumber her interest, or even transfer it in trust for another. Also, if the interest is not conditioned on the beneficiary's survival, it will pass by will or by intestate succession. A. Rationale. The beneficiaries are equitable owners of the trust estate. Their interest's title are property, and each therefore has power to transfer and convey her interest in the trust to the same extent that she could transfer her other property. B. Transferee's right. Here is what is likened to AFV-RFV, but is not actually that. A beneficiary can assign only such interest in the trust as she has. The transfer is not a transfer of the trust res itself, but only of an equitable interest, beneficial title therein. Whatever conditions or limitations a lien attached to the beneficiary's interest prior to the assignment apply against the assignee.
All right, so this is where it starts to get more complex, and we might want to just ask for some clarification on exactly what all that means. So let's just do that. All right, so can you break that down and make it a little bit more understandable for everybody that's just a layman?
Sure. Here's a plain layman breakdown of that paragraph. What Walters quoted, summary. Trust law says a beneficiary's interest, their share rights in the trust, is freely transferable unless the trust document forbids it. A beneficiary can assign, pledge, or give away their beneficial interest. If the beneficiary dies, their interest passes by will or inheritance. Beneficiaries are equitable owners, meaning their share is treated as property. But they can only transfer the equitable interest, their rights, not the trust property itself, the res. Any conditions, limitations on their share carry over to the new person they assign it to. Layman's version. If you're a beneficiary in a trust, your piece of it is like a property right. You can hand that right off to someone else, sell it, pledge it, or gift it, just like you can hand off other property. But you don't give away the actual stuff in the trust, the house, money, etc., only your right to benefit from it. Any strings attached to your share stay attached when someone else takes it over. Basically, you can transfer your seat at the table, not the food on the table.
So now let's move on to the next paragraph.
1520, that becomes the hot potato. Whoever I give it to or assign it to now has the hot potato. That would be the person I would return it to. Once it's attached to the beneficiary's interest, I flip it, flip the hot potato to the new assignee, and that hot potato transfers with it. There is your AFV. That is how we would treat something similar under trust, but it is likened to a debtor-creditor. It comes into being able to make the claim that there is a trust. What if the judge says, I don't see a trust here? You have to prove a trust. That was the Mack truck door opening for you to drive that truck through when the judge says that. That is an opportunity to prove the case that there is a trust. How am I going to prove that there is a trust? Intent and purpose is by the grantor. That is pretty simple. The parties is also simple. There are only 3 parties to the trust: grantor, trustee, and beneficiary. Since I am the grantor making this out, signing everything, granting everything by my signature, all I have to do is define who the beneficiary is and who the trustee is. Then the specific res would be the actual offer itself or the case itself. What I would turn into the trust res by claiming by using the moving titles platform. If there was not a title, I would have to create a title first, claim that title, then merge that and move that title if necessary, if I wanted to terminate the case. Or I could come in and compel the trustee to do the duty for the disbursement if he didn't do it. There are 2 options there I have. The third step is to collect on the disbursement after I expressed and proved the trust in the first step. Step 2 would be creating, claiming, moving, and merging the titles. Then step 3 would be collecting on the disbursement. Whichever way I do number 2, I'm going to end up with the same thing in number 3, collection on the disbursement. I've got the specific trust res as property. I'm putting it into special deposit. Once I put it into special deposit for the purpose of whatever I wanted to use it for the beneficiary. If I am the beneficiary and the grantor, then the trustee has to do the duty to say pay the obligation, which is nothing more than the same scenario on a mortgage. Everything is really operating the same way. Once we get the model down, we can put the model up and apply it to anything at all. Any kind of offer that comes into the mail, whether it be an indictment, a charge for a bill, or whatever you want to call it.
I think we need that one broken down for the layman.
Got it. Here's a layman's breakdown of that hot potato paragraph. Key ideas in plain English. Hot potato equals beneficiary's interest. If you, as a beneficiary, transfer your interest, the obligation strings go with it. Whoever you hand it to now holds the hot potato. Judge challenge equals opportunity. If a judge says, I don't see a trust, that's your chance to prove the trust exists. How to prove a trust? You need the 4 elements: intent, purpose, parties, res, the property thing. Parties equals grantor, creator, signer, trustee, and beneficiary. Res, the thing in trust, Could be the actual offer, like a bill, indictment, case, etc., or a title you create and claim, then merge, move into the trust. Two options once trust is established. One, compel the trustee to fulfill their duty, like making a payment disbursement. Two, terminate merge titles to end the case. Steps Walters lays out. 1. Express and prove the trust. 2. Create, claim, move, merge the titles. 3. Collect on the disbursement, get the payment benefit. Special deposit equals trust fund. Once you put the res into a special deposit, the trustee has a duty to use it to pay obligations, just like in a mortgage model. Big picture, Walters says this trust model can apply to any kind of offer, a bill, indictment, or charge.
Yes, sounds good. Let's move to the next paragraph.
Proving that trust, I am going to have to be able to create records that are evidence that are not objected to in court. I have to know a little bit about evidence rules. And one of the things we use is a notary, because a notary's record is self-authenticating and is outside the hearsay objection to hearsay rule. That is why we use a notary on everything. A notary is going to certify it, and that notary record actually becomes the evidence I need to prove the trust, because a trust forms upon the present transfer of the trust property, the offer. Whatever the trust property is, the specific trust res when I form a record of a transfer, which is one of the methods of formation of a trust. When I have two records to substantiate the transfer, then I've created a trust. There are four methods of creation of a trust. 1. Declaration by words or conduct. 2. Transfer, which is under UCC 3.200s, which is negotiation. A. Endorsement, which is a signature. Anytime somebody signs, that is an endorsement. B. Delivery. C. Assignment. That is what we are going to do on a UCC 3 after we claim it on a UCC 1. D. By operation of law. 3. Appointment. 4. Contract, which is going to be formed in the future in the trust. The one we are going to use the most is number 2. Transfer, which is going to be an endorsement and a delivery. I'm going to prove endorsement on a green card sent by certified or registered mail. When they get the green card, they are going to sign it. The signature is like an endorsement. It's going to prove also delivery, which is one of the methods under transfer.
All right, let's move to the next paragraph, and then I'll have you break down everything after that.
Here, a method of transfer, representing transfer, or method of formation of trust being endorsement. We have delivery and assignment on a UCC 3. When I do a UCC 3, after claiming it on a UCC 1 that it is mine, I can do something with it, assign it to somebody. I'm going to assign it, say, to the trustee, whoever that may be. The trustee is going to be a present transfer, proved by the endorsement and delivery with the green card of a specific title representing the trust res. At that moment, the trust is formed. I'm going to have a notary certify that it was done on a presentment, endorsed, and delivered on the green card. I'm also going to have an assignment on a UCC 3 and certified copies of that pulled out. I am also going to put a notice in the county of a filing UCC 1 and pull that out certified. Now I've got multiple records to prove that I transferred trust property. That is the main thing. To prove by record that you transferred specific property to the trustee, that is when the trust forms. Now we've got a trust. I can prove I've got a trust.